What ridiculous public nuisance laws almost passed? Imagine a law that would have made it illegal to whistle in public or even to sing loudly on your own porch. Sounds bizarre, right? Well, some lawmakers have actually tried to pass laws that push the boundaries of what we think is reasonable about public behavior. These laws are often rooted in the idea of avoiding public nuisance fines, but some proposals go way too far. Over the years, there have been attempts to expand public nuisance laws to cover things that are perfectly legal and harmless. For example, some cities considered laws that would classify the manufacture and sale of legal products like automobiles, tobacco, firearms, or even opioids as public nuisances. The idea was that because these products could be misused or end up in illegal markets, they should be regulated as nuisances. Courts, however, generally rejected these ideas because they are too broad and would unfairly target lawful businesses. One of the most unusual ideas was to treat the lawful sale of firearms as a public nuisance. Some lawmakers argued that because guns sometimes end up in illegal hands, they should be considered nuisances. Most courts dismissed these claims because the connection between selling guns legally and illegal misuse is too indirect. It would be unfair to penalize all gun sellers for what some criminals do with their weapons. There were also proposals to target tobacco companies, claiming their products were nuisances because of health risks. These efforts led to huge settlements but raised questions about whether nuisance laws should be used to regulate legal products. Similarly, some tried to use public nuisance claims against manufacturers of asbestos or opioids, even though these are legal products. The argument was that their misuse or the harm caused by their use made them nuisances. Many of these proposed laws included vague phrases like anything that is injurious to health or offensive to the senses. Courts found these definitions too fuzzy to enforce fairly. They worried that such broad language could be used to target almost anything, making it hard to determine what is truly a nuisance. These near-past laws show how the idea of public nuisance can sometimes stretch into the absurd. They highlight the challenge of balancing public safety with fairness and clear rules. While it might seem silly to label everyday products or lawful activities as nuisances, these proposals reveal ongoing debates about how to regulate social harms without overreach. Courts often push back against overly broad claims, and legislatures need to be careful when drafting laws to avoid creating laws that are too vague or unfair. These stories reminded us that even in the world of law, sometimes the ideas are more wacky than practical.